So I'm Michael Mack. I'm the CEO of the Family Mediation Trust, and I'll just start by giving a bit of an outline to where we've come from. The Family Mediation Trust was formed this year as a partnership between Norfolk Family Mediation and Cambridge Family Mediation. Both these services had been set up in about 1983, so they've been around for quite some time, providing mediation to sort of Norfolk and Cambridge predominantly. And in that role, we've always provided legal aid provision and targeted those families who can't always afford mediation, want to try and make mediation accessible to everyone, really. So we decided, having run both services, it became very clear that actually merging them would make a lot of benefits for us. So we have taken that step this year during COVID, which has been quite a fun challenge. We've also moved office in Cambridge to be in partnership with the CAB in Cambridge. And the third bit of the jigsaw is, I know that in Peterborough, those who work in Peterborough, the family mediation service in Peterborough closed down in September. So we've also extended our services there to make sure that legal aid provision was available there. So that's sort of the background of where we've come from. And today we've put this presentation on so that we can help give you confidence and understanding in how mediation works and help you guide clients into mediation that can be helped in through our service. And the only way that you are going to be able to do that is by giving you information and answering your questions and concerns about it. So that's really what we're aiming to do today. If I can ask you all just to mute your audio so there's no sort of background noises. There will be a lot of time to ask questions. If anyone's got a question at any time during the morning, if they just raise their hand, then we'll be able to come back to them and answer their question. There'll be a couple of breaks to ask questions, but actually if there is something specific you want to pick up, please just let us know and we will deal with it. If you've got a problem with your microphone, I know someone has, it just popped up. If you want to type the question using the chat function, then we can get back to that question as well. So that's fine. Jane Bridge is co-delivering today with me, not Helen Casey. Jane has been mediating for the service for well over 20 years, and before that she was a family barrister, so she's got a wealth of knowledge and understanding, so she will be delivering most of the presentation after I've just done the introductions. Okay. So one of the bits of the background for us is we all know that COVID has had a significant effect on families and the number of people separating. In Norwich Court alone, there has been a 12.4% increase in the number of applications to court for family matters during the period of COVID compared to last year. Last year was 13% up on the year before, so you can see it's a constantly growing challenge. And what the judges are picking up, and this is a quote from a statement made by Judge Warblood, who I believe is the sitting family judge in Bristol, and effectively he's setting out that the courts should be there for cases that need to be there, and for matters that can be dealt with through things like mediation, we should be working really hard to keep them out of the court process as much as possible. To give courts the time to focus on the cases that are really important and needing that judicial input. I know as a sitting magistrate in Norwich how challenged the courts are. If you just put this into context, Norwich used to have 6 courts running every day. It now has 2. So just putting that into context, you can see how that will impact on the amount of cases that can be dealt with. With more cases going in, slower the processing of cases when they are in there is all impacting, and therefore mediation is a key tool that we all should be looking at for cases where there's a separation going through, subject to being safe to do so, which we'll go through later on. And the second bit of this is there's a report issued last week or the week before. What about
the week before?
Week before, and it sets out a whole new sort of direction for the family courts processes. It sort of identifies that there's some significant failings in the court services at the moment, and that we need to react to that, and we need to target how we keep people who are on the sort of the cooperative parenting pathway, we need to make sure things like mediation are done effectively. So they will be starting to police things like MIAMs in the courts a lot more effectively. They'll be expecting both parties to have attempted a MIAM rather than just the one. There's a lot of steps that are likely to come through here. There'll also be a safety pathway, which is really targeting the court resources towards those people where there's a safety issue that needs to be managed, so that they can be managed more effectively and quicker. But on the background of both those bits, those findings coming out and the report coming out, there is a time when we need to start making sure we use mediation and cases are referred in, and that the whole conversation with clients is a lot more positive about how mediation can help. So I'm going to pass over to Jane, who will introduce herself and sort of really focus on how mediation can help the clients that you all are getting calls from. So Jane.
Hello, everybody. Thank you very much for giving us the opportunity to speak to you this morning. Yes, just picking up on what Mike has just said about the Family Solutions Group report that arose out of the private law working group set up by Mr. Justice Cobb, and in which the president of the Family Division has been very much involved too. And the report says, it doesn't pull any punches, it says that the family justice system is broken and that it is not working. It's overloaded, it's overworked, it's under-resourced. And therefore, the pressure to look at alternative methods of resolving issues, particularly between separating parents, and focusing on what children need for the process rather than on what parents' rights are, what children's rights and needs are, is becoming very central to the work that we all do. Have I skipped through us? We've gone straight, yeah, okay. In terms of referring people into family mediation, people want to know really what is going to happen to them through that process. And what we do is to meet with the parties. Our role is to be impartial, neutral, balanced between the two of them, and to try to help to guide them through the process and to focus on resolving issues that they have. As Mike referred to just now, we do see clients separately at intake before there's ever any question of a joint appointment. It's so important that the whole process is seen as voluntary, whatever the pressures might be from the outside on clients to come into mediation. And so when we see clients separately at the start, we check out very carefully to see whether there have been issues of domestic abuse or violence or any child protection issues involved in their situation. And if those do arise in the intake session and they haven't been looked at or dealt with elsewhere, then as mediators, we have a duty to refer that issue on to the appropriate agency or authorities, children's services, if it's child protection issues. And it's important that clients know that that first meeting with us is entirely confidential and legally privileged, save for any breaches of confidentiality we may have to make in the event that that we feel we have to take action in terms of all the things I've mentioned. The fact that it's legally privileged means that even if the parties do end up in court, then nothing that has been discussed within the mediation process can be asked about in court. They can't be asked to discuss or tell the judge what has been said in a mediation meeting. Where there are finances involved in mediation, then there are slightly different criteria, and financial information given through the mediation process can be referred to in a court situation, in provided that certain circumstances are in place. So just moving on to the next slide. Seem to have got stuck here. Okay, there we go. Who can use it? A really big question. Obviously, you know, parents who are separating can use it. We've talked about them, But I'm wondering if anybody has any ideas about other sorts of cases or other people that might be suitable for mediation services. Any ideas from any of the attendees?
Does it have to be parents? I mean, can it be a couple separating with financial issues just?
Absolutely, yes, it can. And sorry, I don't know who that question came from. Who is that?
Sorry, I should have identified myself, Jane.
Lovely, Jane. Okay. Hello. Hi, Jane. Jane to Jane. Yes, absolutely. That's a really good question. Yes, it doesn't have to just be issues about children. We deal with mediation in terms of all issues relating to family breakdown. And a typical case would include children, finances, including the house, pensions, other perhaps investment properties, family companies, and investment portfolios, trusts, anything that the family is having to deal with through the breakdown process is suitable as discussion for discussion in mediation, provided that both parties are happy to discuss those things. What we can't do is to have one client come in and say they want to talk about the children only, and the other wants to come in and talk about the children and the finances. That second person can't push the finance agenda onto the first person if they're not willing to discuss that as well. So that's very much a part of our agenda setting, and I'll talk a little bit about that later.
But could I ask a very sorry, I didn't mean
no,
to
please
interrupt.
do.
Can I
No,
ask
don't
a quick question?
do feel free. Yeah.
Because you said, about the financial issues, pensions or whatever it will be. Do you have then people with financial expertise?
You mean in terms of the clients, Anita?
No,
or
no,
in terms
of the mediator, to understand, if it's a complex financial issue, are they trained for that as well, or how does that work?
That's a really, really good question, Anita. And I should say at this point, please feel free to interrupt us at any point. If we start to run out of time, we might call a halt on that. But honestly, it's going to be a much more interesting presentation for you if you can ask things as we go along. So never feel worried about putting up your hand. That's a really good question, Anita. Part of our foundation training, we have to do an 8-day foundation training before we even start to build a casework portfolio as part of our qualification process. And part of that training is looking at the legal framework and learning about the financial framework that applies within mediation. Now, some mediators come from a family law background, and we happen to have quite a few in our service, but many mediators come from a therapeutic background. And so what happens as part of our training is that we each learn skills that the other types of mediators have as part of our foundation course, and then as part of our worked portfolio of cases that we do over the next 2 to 3 years after the foundation training. And so working through a portfolio of cases, you come across with other more experienced mediators working with you, lots of different scenarios, and you gather that knowledge like a kind of rolling stone as you go through the years of training. But having said that, in a complex mediation case, then it may be to bring in an expert. And there are cases where clients might want to perhaps consult a neutral financial advisor and to perhaps then have them be part of the mediation, perhaps for a session or two, or they may want to have somebody accompany them to a particular session. And that can always happen, provided that both parties are happy with that and the mediator feels that the process is suitable for that. But it's right to say, and we'll come on to this a little bit later, that mediators are not allowed to give legal or financial advice to clients. We are allowed to give financial and legal information, and we do so all of the time, but we have to do that in a very even-handed and neutral way so that it applies to both parties, and we do direct them and recommend very strongly that they take legal advice outside sessions and bring back the results of that legal advice to sessions, to the next session, and equally that they take financial advice outside sessions and bring that advice back into sessions with them. And I think there has been, over the decades, sometimes a lack of understanding, and this is to do with the way mediation has perhaps portrayed itself over the decades, that mediation is only really suitable for child cases, and that it's not, that mediators are not really up to dealing with finance cases. But I should say that, a large percentage of the work that we do is to do with finances as well. And so it's entirely suitable for those cases. And that's part of our assessment process. But that was a really helpful question, Anita, and it's perhaps stopped me duplicating some of that information later on in the presentation, but it's a good point to raise it at. Has anybody else got any questions about? Mike, did you want to say something?
No, sorry, Sheila.
Sheila. Have you got a question, Sheila?
Yes, I have. I know that mediators need extra training if they're going to work, especially with children. Do you see children separately from their parents when there are issues such as access or contact and so on?
Yes, we do. That's a really good question too, Sheila. And we have a little slide coming up later about that. So if I may, I'm going to focus on the child inclusive mediation aspect a little bit later on, if that's okay, and go through that in some detail. That would be, so it's a really interesting and growing area. I just wanted to perhaps put up now the list of people who can use mediation, and just to let you see how wide the kind of numbers of different categories of people can be. And I should mention perhaps specifically that we're seeing more and more disputes in which grandparents are involved, and that can be either perhaps because they've lost contact with their grandchildren through the breakdown of the family situation, or sometimes because perhaps unfortunately one of their children has died and they've taken on the care of their grandchildren, or one of their children has drug or alcohol issues and isn't able to care for the children. So, that's becoming a wider category of cases too. And we have also done some public law cases in which there perhaps is a special guardianship order or an open adoption order, where we've helped to negotiate contact and arrangements between birth parents and the parents who are looking after the child, or special guardians who are looking after the child at the current time. And we're also getting quite a few more issues to do with inheritance. In fact, I think I have a case next week in my diary to do with an inheritance issue, which often turn out not to be so much about the money involved, but about the breakdown of the family relationships that have actually led to that issue, that dispute. So it's, and we do see lots and lots of unmarried couples, of course, are separating as well as married couples. So a wide category of people. So when can mediation be used? It can be used before, during, or after court proceedings. It can be used at any time by anybody who wants to use it. And it's quite often happens that we have cases these days that ping pong between mediation and court, so that perhaps people might start in court, the court refers them out and asks them to try mediation. They come and try mediation, they perhaps resolve some but not all the issues, and then they go back to court to resolve the remaining issues that are outstanding. And sometimes we have cases where there's been perhaps a long history of litigation and that there's been that toing and froing. And then people come to mediation in the end because they're exhausted with the litigation fight. They've run out of money and And quite often mediation can be very helpful at that point because they know that the alternative isn't working for them, and it's a really good solution. What does it cost? Now, I think this is probably a slide that you're going to be really interested in and wanting to know details about. So we can spend a little bit of time on this, because I know a lot of clients ringing in for advice and assistance to CABs will be very worried about money. And so it's important to know that mediation can be provided for free for those clients who qualify for legal aid. And not only that, but the government does offer a carrot to the second parties in cases where legal aid is available for one or other of them. It does pay also for the first assessment meeting, the MIAM, for both parties, and for one free mediation session after that, before the person that does not qualify for legal aid would have to start to pay. So it can be a huge benefit to both parties if at least one of them does qualify. If clients just miss out on the legal aid eligibility and that on living on below the living wage, then we do have a reduced private rate for them of £120. And that is for a 1.5 hour session. It includes VAT and it includes the cost of all the paperwork that we do at the end of the session. But if clients do not qualify for legal aid and they don't qualify for the reduced fee, then they pay £180 for each 1.5 hour mediation session after their MIAM. And the MIAM costs £119 if clients are paying privately. And it's worth saying that looking at perhaps a pretty average scenario for a child issues case would be that both clients come in for a MIAM and then perhaps they come in for 1 or 2 sessions. Let's say they come in for a MIAM plus 2 mediation sessions. A person on less than living wage for that service who didn't qualify for legal aid would be paying £359 for that MIAM plus 2 mediation sessions. So that's their total. If a client was not on the reduced fee and was paying the normal private fee for clients, and they had a MIAM plus 2 mediation sessions, then they would be paying £479 in total for the whole of that process. If they came in and had to have, say, 4 mediation sessions, they'd be paying something like £840 for the MIAM plus 4 mediation sessions. So you can see that even if the case lasts, as long as 4 sessions, and that would include often both the resolving child issues and finance issues, still for under £1,000, they are having a pretty good value process to get them through the large bulk of the issues that they are having to resolve. So I just wonder, I might pause there just to ask if there's some questions at this stage, because I know that this is something that you might want to know a bit more detail about.
When a clients first contact you and attend, are you able to go through with them about whether or not they're eligible for legal aid and help them apply?
Yeah, that's a really good question, Jane. Thank you. Yes, that's exactly what we do at the MIAM meeting, the Mediation Information and Assessment meeting. The very first thing we do is to go through their legal aid eligibility if they think they might be eligible or we think they might be eligible. And that requires them to produce for us their financial documentation. We send them a list of what is required prior to the session, and where possible they send in their electronic version of their financial information prior to the session, so we can have a quick look before the session starts, and then in the session we'll go through it item by item with the client and make an assessment with them as to whether they qualify or not. And if they do qualify, then it's free for them from that stage onwards. And just bringing up this slide that gives a little bit more detail about that legal aid assessment, Jane. If people are on passporting benefits, and that, thankfully is becoming largely universal credit now, it's starting to make the assessment process a little bit easier than when people were on a real raft of lots of different tax credits and benefits. If somebody's on universal credit, then unless they have either a valuable house or a lot of savings, if they're on universal credit, they're likely to, that they should certainly be assessed, and they're likely to qualify. The income threshold that we have to meet, so after we look at their income and make the allowed deductions, then the threshold is £733 a month. They have to be below that in order to qualify for legal aid. They have to have less than £8,000 in savings, and even if they have a house, there are certain disregards that we can allow against that may well still mean that they might qualify for legal aid even if they have a house. And so it's always worth people asking for that assessment. We're always really happy to do it, and if they don't qualify on the day, then we can always offer them a further assessment on a different month if they feel that that was a worse financial month for them, and that would bring them within the eligibility limits. So we always do what we can to bring people within the legal aid umbrella if we can do that. Does that help, Jane? Good, thank you. I think your microphone's off very nicely, thank you. Any other questions about legal aid at this stage from anyone? Okay, that's great.
Sorry, there's a hand up.
A hand gone up, yes.
Manuel.
Hi, Jane. I was wondering, will this session be together? So will the parents, if they want to be together, have the meeting together, or will the meeting be separate, so individual meeting when you go through the financial documents?
Oh, thank you, Emmanuel. That's a good question as well. We always see people separately when we are doing the MIAM stage. Prior to lockdown, we did have such a thing as a joint intake session where both parties would attend the office together. But even then, we would see each party for probably up to 30 minutes on their own, out of the hearing and sight of the other party, and discuss their situation separately, do the legal aid assessment separately. And then once we'd seen both parties separately, we would then bring them together into the room to see whether or not, having heard what they heard from us about the information about mediation, whether they were wanting to go forward with the process. And the advantage of that was that we could perhaps run through the agreement to mediate with both of them there and then, and give them financial packs to take away and fill in, and sort of get them started jointly, because all the research and evidence on MIAM shows that where you can get the second party in so that you can engage with both parties, then there's a much higher likelihood, I think it's up to 70% of people then going on to mediate. So obviously with the online and lockdown situation at the moment, that's not really, we can't really do that in the same way. But we do everything we can to contact the second party after we have seen the first party, to make sure that both parties have the most opportunity they can to engage with mediation if they can at that stage. But thanks for asking that, Emmanuel. That's a really good question. It's something that worries clients a lot, is that they might have to see the other person, and the answer is absolutely not at the assessment stage. And thank you for that. Any other questions anyone's got at this point? Okay, move on. So how long does it take? I mean, typically we can see people within 6 days of them contacting us. It might even be sooner if we've had a cancellation, or if it's a slightly quieter time, although that's not happening right now. We're very busy at the minute. As I said before, child-only issues typically would take 1 to 2 sessions. All issues cases, that's where children and finances are involved, then typically it would be 3 to 4 sessions. Sometimes it's less if they're very well prepared and have an idea as to what they want to do. Sometimes it's a bit longer, perhaps if it's a more complicated financial case, perhaps there's company accounts to get hold of, or pension values that take sometimes up to 3 months to get hold of, or we need to ask them to get separate legal advice or financial advice between sessions. That can lead to perhaps there being a larger number. And we space those 1.5 hour sessions out to meet clients' own needs. But in most cases, we can achieve quite substantial progress in under 6 weeks. In fact, I'm working with some clients at the moment. I think they've had a mediation last week and the week before, and they have another one at the beginning of December. And so within quite a compact period of time, they are going to hopefully have reached some really good, sensible parenting arrangements in what has been quite a high conflict and difficult case. So, yeah, it just gives you a flavour for the sort of time scale that we're looking at. Who attends, and picking up again on Emmanuel's point there, after their separate intakes, then both parties do attend together, unless there are exceptional circumstances in the case, and they will usually see the same mediator unless something dreadful happens or the mediator goes off sick or something, or the mediator and the clients fall out and they ask for a different mediator. Occasionally that's happened, but not many in the 30 years that I've been mediating for. And sometimes if it is a very high conflict case, or there are other issues that make it a good idea to do this, we do sometimes do shuttle mediation where that's appropriate. And that might be perhaps in a particularly high conflict case where the parties find it difficult to even see each other on screen together. And that does happen in certain cases. And often at the start of a case like that, we would suggest and use shuttle mediation. And it may be that as time goes on, through that shuttle mediation, particularly in a child case, we may be able to work towards seeing both people together, either on screen or in person, if we're ever lucky enough to be able to ever do that again. And so, particularly where children are concerned, we always aiming to try to get people making decisions together where they can and where that's safe to do so. But we have a range of strategies and skills that we draw on in high conflict cases to make sure that people feel as safe as possible in expressing themselves and that they get the support outside of mediation that they need. And we will signpost them to support services if we're concerned that somebody is struggling, and obviously stop the process if we feel it's being misused or abused by either party. So to make it work, to make mediation work, there needs to be a willingness to cooperate, however minimal that might be. And as you'll appreciate, trust is usually at an all-time low when clients reach us in mediation. And sometimes they haven't spoken for months, sometimes not for years. And so it can be a really powerful and difficult thing for them to even see one another on the same screen, never mind be in the same room together. So we're always very aware of that. The parties need to be competent in the sense that they need to be able to express themselves in the session. And sometimes we have had where people have difficulty in expressing themselves. Perhaps they've been through certain difficulties or they find reading and writing difficult. Then we have had advocates come along with them to help support them in the session, or family members. And of course, where language is, perhaps English is a second language, interpreters to come in to make sure that people feel that there's as much of an equality of bargaining power and a level playing field as there can be when they're discussing these very difficult issues. So people don't have to actually engage in a joint mediation session before they apply to the court. However, these days, before clients make an application to the court in relation to either child issues or money issues, they do, generally speaking, have to attend a MIAM. There are certain exceptions to that. For example, if there's been serious and recent domestic abuse or violence in the situation, or if there's been safeguarding child protection issues, then there may be exceptions to that rule. But generally speaking, people do have to come and learn about mediation on their own in a single meeting with a mediator without the other person present, to find out what mediation is and what mediation could do for them. And we, in almost every case, also contact the second party, even if we've decided that mediation is not really suitable to go ahead for various reasons. We will still, generally speaking, contact the second party unless it's going to make things worse for the family, and give them the opportunity to come in and hear about mediation, even if we know that it's not going to go ahead because it's not suitable right now. Alicia, you've got a question. Would you like to ask it?
Yeah. I was just, I mean, I know obviously there's things like, domestic abuse or very violent cases where mediation wouldn't be appropriate, but what sort of other situations do you tend to commonly find where you decide mediation isn't really the best path forward?
Okay, that's a really good question, and it's a sensitive balance of judgment, really, Alicia, based on experience. If we feel that there is too big an imbalance of power between the clients, and it may not amount to what one would define as domestic abuse or domestic violence, but we're aware that one party is perhaps at a very, very low emotional point. They're perhaps struggling with depression, maybe clinical depression, or something not something short of that. But I mean, I'd say at least 60% of the clients that we deal with are in a low mood, if not clinically depressed, and will need support either from their GP or through counselling, through medication, to help them to get through the period of the breakdown of the relationship. And sometimes that can impair somebody's ability to be able to put forward what they want to put forward on that day, and in mediation with the other person present. And sometimes that leads to too great an imbalance, that the clients are at too far apart on the spectrum of managing the separation for it to be a fair discussion between them. And although the mediator is trained to help to support both people to express themselves, if the imbalance is so great that the mediator would spend a very great deal more energy and time having to support one party to express their views, then the other party may well perceive that as being unfair, and that the mediation is being biased, and so on. And so it's a careful, kind of sensitive judgment that has to be made as we go along. It's not always apparent just from the assessment meeting. It sometimes doesn't emerge until you start to work together with the clients. And at any stage, the mediator has got the ability to pull the plug on the session and on the process if they feel that it's not going to help clients. And occasionally we do that. We have to call a halt to it if we feel that it's not going to be appropriate, it's not helping things. So that's one particular situation. Another might be where one party has perhaps never had anything to do with the finances in the marriage, and they need to discuss the finances in mediation. Sometimes the worry on the part of one party that they just don't have the information and don't feel that they are strong enough to be able to withstand the suggestions being made by the other person who's always dealt with them. That could be another typical scenario where the imbalance may be too great. Although in cases like that, I would usually still encourage people to try a session, because my experience has been over the decades of doing this that often mediation can be quite empowering for clients, and often where perhaps one client has had less to do with the children, more to do with the finances, then there can be a balancing up with the other person who's had less to do with the finances but more to do with the children. And through the mediation process, we help them to exchange information about all of those subjects. And so it can be that people grow in confidence as they realise that, yes, they can have more input into their children's lives than they had during the marriage, because it's a time to reanalyze things, to look at things, to change priorities, and to look at different ways of doing things. And so that's very much a part of our remit, is to help, you know, clients also to grow through the process in that way. And I've very, very often seen that happen. So I don't usually write off mediation completely at the start, if just because I have a suspicion that one person may be too challenged by it. It's often worth giving it one session to see how it goes, and then and then taking a rain check with both of them to see how it's felt for them and whether it's going to help moving forward. Does that help?
Yeah, that's perfect. That's great. Thank you.
Okay, great. Just to perhaps recap as well on the accreditation process as a mediator. I know we've got Paulette here, I think, from the Family Justice Council, so she'll be well used to looking at the accreditation process, I'm sure. And once you've, as I've mentioned before, passed the 8-day foundation course, you have to then have completed a portfolio of cases that can take up to 2 or 3 years. And once you have worked with a more experienced mediator to put that portfolio together, and you've attended the required supervision over the course of that time with your professional practice consultant supervisor, then that portfolio is submitted to the Family Mediation Council for approval, and then assessors are appointed to have a look at the portfolios. They will take a matter of weeks to go through those in detail, and then to let the mediator know at the end of that assessment process whether they have passed or whether they have provisionally passed and need to do a little bit more in order to become fully accredited. So it's not a training that is to be undertaken lightly. It takes a long time, it takes commitment, and you really have to want to do it to complete it. And once you are accredited, you then have to accumulate an appropriate number of continuing professional development points each year, and to re-register with the Family Mediation Council every year, and to reaccredit every 3 years. So you have to produce evidence of what you've been doing to keep up to date, learning that you've had adequate supervision and so on, in order to maintain your membership of one of the membership bodies and to be accredited by the FMC. So it's a pretty serious commitment. So just briefly, mediation then, as I've highlighted before, provides clients with that opportunity to re-establish communication, provides them with that, hopefully, that safe place for face-to-face meetings, whether those are in person or online at the moment. The mediator supports the negotiations in an impartial, balanced way, and helps those clients to exchange information within that structured framework. And then we help them to look at the options that they have for reaching a fair settlement between the two of them. And where necessary, we, as I said, divert them and recommend that they go and get some legal advice. But the most important thing of all is that we help them to make their own decisions. They retain control over the decision making. The mediator never makes decisions for them. We don't tell them what to do. We don't give them advice. What we do is to support them along that journey of sharing information, looking at the choices between them, and helping to support them to make their own decisions and to come up with an agreement that they can both live with and that they both feel can help them move forward. And in the actual mediation meeting, as I mentioned, I think a little bit earlier, the very first thing we do is to set the agenda, find out from each person what it is that they want to use the session for that day. because quite often the agenda will change from session to session. We need to make sure what their priorities are for that day, and we take the lead then from the clients in times, setting the appropriate time scale for discussing those various topics, so that we help them get the most out of that hour and a half. We run through the agreement to mediate with both of them, make sure they're in agreement with that. Those are the sort of ground rules for mediation. We'll help them to work through a parenting plan to try to anticipate any of those difficult areas that they need to agree between them. You know, how they're going to share time with their children, how they're going to manage children's birthdays, parents' birthdays, Mother's Day, Father's Day, Christmas, school holidays, half terms, contact with new partners, contact with extended family. All of those issues can be discussed and talked about in mediation in terms of child arrangements, and then we help the clients to put together a parenting plan that they can take away and use to work forward on. And as I've mentioned, in a financial case, we will help them to exchange their disclosure of all the assets they have, any debts and liabilities they have, to look at what each of them is earning and what the likely monthly expenditure budget for each of them is, help them look at what housing options might be open to them, and help them look at what options there are for a fair financial settlement. And in the knowledge that any financial settlement through divorce or dissolution of civil partnership has to be approved by the court. Even if they agree something in mediation, it's not necessarily the end of the story, because in order to finalise their divorce or dissolution, they will need to have the court approve that. And so mediators, together with solicitors and clients, all work within the criteria that the court will apply when looking at financial settlements. We use summaries at the end of each mediation session to record the progress in the session. It's not a verbal report of what happened. It's a list of the things that they've agreed and the things that perhaps tasks they still need to carry out before the next session, prompts for them to get legal advice and so on, in order to help move things forward. I promised, I think it was Jane earlier, or it may have been Sheila, I can't quite remember now, that I was going to...
Stop there a second, we've got a question.
Oh, sorry, right.
Yeah. It's not a verbal one, that's all. What are the expectations for clients between sessions? Can they keep discussions between themselves, or is it preferred if that all happens in the sessions?
That's a great question, whoever asked that. Sorry, I haven't looked at the chat box recently, but that's a really good question. If it's a high conflict case, particularly if they're still living in the same house because they haven't been able to afford yet to separate, and we're conscious also perhaps that there are children in the house, then we may ask the parents to agree between them that they don't try to discuss things outside of the mediation session if we think it's going to trigger perhaps a more emotionally charged and difficult environment in the house. But where you do think clients are able to continue to discuss things outside the session and to keep things as reasonably civilized, then it can be extremely helpful if they continue to perhaps exchange information or to trial out ways of communicating that we might have discussed in the mediation session. And so where people are able to safely continue to discuss outside mediation, I'd always encourage that, because that's showing that mediation works. If they feel able to continue their discussion in a constructive way, then the mediator's doing their job. And I always would encourage that. But it's a case-by-case decision, and we're always sensitive to what is likely to go on after the session, not just what's going on in the session. And so it's a question of feel and balance, and you build experience in that as you go through the years as a mediator. Does that help? Okay, good. And I did promise that I was going to say a little bit more about child inclusive mediation. And we do sometimes see children within the mediation process without their parents present, generally speaking. And it's a growing area of work, and the Family Solutions Group report that we mentioned in the second slide at the beginning of this presentation does place a lot more emphasis on children having a voice within all the processes that affect their well-being and upbringing and future, whether that be through the court process, whether it be through solicitor-led negotiation, or whether it be through mediation. And so all mediators are alert to give parents information about child inclusive mediation. And the emphasis is, the current thinking is that where a child is aged 10 or more, then they should have the opportunity to have their voices heard within the process. And there can be reasons why that is helpful or not helpful in any particular case. And we'll give the parents that information and discuss the possibility with them. It needs, if it's going to go ahead, to have the consent of everybody involved. So both parents need to agree. And of course, the child or young person needs to agree also. And if everybody's in agreement, then we invite the child to come in. We either do that by email or often a letter, because children like to receive letters, generally speaking. And we arrange a time. At the moment, we're having to see children online. But before lockdown, they would come into the office for a meeting. And we have up to an hour with the child to talk to them. The purpose of the meeting is to give the child, a safe place to express views about the family situation. And if they've got any ideas about things that they think mum and dad could do to help make things easier for them, the children, then we ask the children if there's anything that they've told us that they'd like us to feed back to mum and dad. We make it clear to them from the outset that the whole process is confidential, and that the mediator is not there to take sides with anybody, and that unless there's a child protection or safeguarding issue, we can keep whatever the child tells us confidential between the two of us. But we agree pretty much word for word with the child towards the end of the session what exactly, if anything, they'd like us to feed back to mum and dad. And it is astonishing how clearly children see things, and how much they see and hear that parents have no idea that they have seen and heard. And it can be extremely powerful where children do give us permission to feed back certain messages to the parents. That when we set a separate appointment with the mum and dad as soon after we've seen the children as possible, so they're not left sort of hanging for too long. It can be very powerful to have the parents hear those messages without any interpretation or explanation from the mediator. We can give just the pure feedback, and we can't interpret or tell the parents anything more about what we think children might have meant by that. And so it can be a very powerful point, and it can really help to move people forward sometimes. The reasons why it may not take place is perhaps because one parent doesn't agree, or the children don't want to come, or the mediator feels, having worked with the parents, that the parents perhaps couldn't be trusted really not to brief the child beforehand and tell the child what to say, or to cross-examine the child aggressively afterwards to ask them exactly what they told the mediator. If we have the feeling that in this particular case, the child might be placed in a difficult or intolerable position if they go through a child inclusive mediation session, then we would perhaps make the assessment then that it wasn't suitable. Again, it's a very sensitive judgment based on experience and knowledge of the case. So I hope that answers the question that came up previously. about that. But are there any questions arising from that?
Sorry, Jane. There's a question of who pays for the session. Just so you're aware, the costs of it are either paid through legal aid. So if it's a legal aid case, they would be covered through those in that way. If it is a private case, then there's a charge of £75 per parent, that they both have to pay their equal proportion of it. We don't rely on one to pay for the other unless they so agree to do that.
Yeah, that's great. Thanks, Mike. Are there any other questions about child inclusive mediation? Anything that anybody'd like to ask?
Sorry, so what if the mediator feels the child view would be of value in a case, but the parents aren't willing to either have that happen or to pay the fee?
Then it won't take place, unfortunately. It has to be completely voluntary, Jane. So we're not allowed to pressure anybody or push anybody into anything. It has to be completely voluntary on the part of all parties concerned. But that's a good question. Thank you. It looks like we've got lots.
The only slight adjustment to that is that as a charity, we do, whilst we set our fees and we have the reduced fee for mediation and things like that in place, we do have the ability that if there is a case that a couple are desperate for it and we can't support it in any other way, we can review our fees. So we would look at that on a case by case basis, and that's sort of part of the values of being a charity. We can do that.
Yeah, that's great. Thank you, Mike. Yeah, we'd contact Mike in those situations and see if there was any wriggle room on the money front. Yeah, if that was the only thing standing in the way. I think Sheila has a question. Is that right?
Yes, I do. Thank you for the comments you made. I did clarify quite a few things. What concerns me most is the final issue on the slide about briefing and questioning of a child by parents before and after. And it concerns me that those perhaps are the very children that would most benefit from the process of mediation, and those parents as well. But I appreciate that it can't be done without everybody's cooperation. I just wonder how you work at trying to get everybody to engage when you realise that speaking to the children might be to everybody's benefit.
Yeah, well, we will continue. I mean, we'll raise it at the outset of mediation, Sheila, and it may be that as the sessions go on, if they come in for more than one session, and we're able to work perhaps in more depth with the clients, it may be that we can raise it again later in the process, that it might be something that is possible at that stage. So we keep it under review at the whole time. Or sometimes cases might go away from mediation. They might finish mediation. We may find that they then come back later and say, actually, we've thought about it and actually things have not got any better, and we really feel that the children do need to have a chat with the mediator. And we would then be happy to hear anything the children have got to say. So even if it's not appropriate or it's not, people not agreeing to it at that present time, just giving them the information may sow the seeds and may make it more appropriate at a later stage.
Right, thank you.
Are there any other questions? Because I think failing that, we've run over a few minutes, but only because there were so many brilliant questions. I hope that's okay. But we have a simple referral process. You can go onto our website, and on the first page there is a referral form that anybody can fill in with the clients. So as CAB advisors, you could go through that with clients on the phone if they're wanting to make a referral, and send it direct to us that way, or they can call the service. And although there are 3 numbers there, they all actually end up in the same place. It's just we've given the kind of local codes and so on, just so that people feel that they're perhaps contacting a local service rather than just merging into one one telephone system. But that's in reality what happens. It doesn't matter which of those numbers they call, they'll reach the same place. But otherwise, just to say thank you very much for your time today and for listening and for such brilliant questions. It's been a really lively session, and hope that you've had all the questions answered that you would like. If there are any more, then Mike and I are here for another few minutes. Very happy to answer any more that you've got.
Thank you so much, guys, for the presentation. I was just wondering if we could have a copy of the document for reference.
Yes, the presentation and the video will be sent round to everyone. We were just waiting for all 3 of the CAB sessions to run before we did that, so that they will come out in the next day or so.
Thank you so much.
Okay. Anyone? Thank you, Jane. That was really helpful. Any questions? Anyone's got anything they would like to understand a bit better? Flora.
Oh, hi. I was just wondering, Jane, how you ended up as a mediator, and Mike as well. Sort of, how did you get into it?
That's a really great question, Flora. I was a family law barrister for 20 years before I saw the light. So I had the experience of seeing clients go through the litigation process and just the emotional bloodbath that people went through in trying to, fight things out in court, not to mention the tens of thousands of money of pounds of money that it cost. And so after about 15 years as a barrister, I found out about this magic thing called mediation way back in the early 90s. And I went off to the first Congress in child law in Sydney in 1993 and did all the alternative dispute resolution modules I could find in the Congress, and realized that Australia, New Zealand, America were all about 10 years ahead of us on the mediation front. So I scuttled back to the UK and joined the next core training course I could find with the Family Mediators Association, which is one of the professional bodies, and did my foundation training and worked my way through my portfolio with a couple of long-suffering supervisors, and started doing mediation in the evenings after I'd finished in court for those clients that wanted it. And then out of that, after a few years of doing that, I realised I wanted to make mediation my sole profession. I went through a divorce myself. I had experience of what that means when you have young children. And I thought, you know what, I think I just want to step back from the bar. It's been a good career for me, but I now really want to go down this path. So I have to say I never looked back, and I love every day of what I do. You never know who you're going to meet, what story you're going to hear next. And, you have a sense of satisfaction, even in difficult high conflict cases, that hopefully you're moving clients from a stage where they're not able to communicate to where they can at least have a basic communication about their children. And that is deeply satisfying. So that's how I got into it. I don't know how Mike got into it, actually.
I was complete. I'm not. I was going to say I don't mediate, and I'm not a mediator at all. I'm here to try and help the charity move forward and go in those directions. So my background is completely different, but Jane's story is so similar to a lot of the other mediators we've got, and I think that's something, and it comes back to why we've got 3 phone numbers. Our mediators are all very local. They all live and work in our patch, and I think that's something that sort of we haven't really covered off much. But when we do get cases that are people who need extra support, say it might be from domestic abuse or something, we know, because we're local and we have that connections, we know those local support services, and I think it's quite a critical sort of element to the way that we work. It's about our mediators are all coming from the community and they work within them. So Debbie in Norwich, for example, who does a lot of mediation in Norwich, she's also the family solicitor for the Norfolk Community Law Service. So you can see those connections all work around, and we can make sure that the clients, if we can't help them, we know the people who can, and I think that's quite a big bit of it. But yeah, all the stories behind all our mediators very similar to Jane's, and they're doing it because they really want to make a difference and help the people who come forward.
That's brilliant. Thank you very much.
You're welcome.
Okay, any more questions?
Just one last one. What's the percentage rate in your experience of clients who end up not going to court, and so for whom mediation is very successful, so that they avoid time-consuming, expensive court procedures? Okay, from our point of view, if we can get that second person in the room, so if we get both attendees attending, we're looking at about 75% of them go on to mediate and get an agreement in place. So it's all about getting that second person to come along is where we put so much effort, because that's the big one. So we probably get quite a lot of the clients turn up on day one purely to get the court form. They've almost switched off in their own minds a little bit about mediation already. All they want is a court form to take it to court. So the team work really hard to try and get them on board and into mediation, and we do have really good success at that. But still, those people are already sort of switched off from it. Those that are open, probably it is probably about half that we get that second party in, and then we can get that conversion really taking place. So yeah, it's a contact in the second party, and we do it once by letter. We then follow that up by phone or letter again a second time before we cut it off. Well, we're doing everything we can. And I think that's often what people realise is both parties are coming into the room, and one is always ready because that's why they came forward as a first client. The other one is probably not ready, might not even know, and it's been 2 years since they've had contact or something. So they could be having to really get their head into a different place completely. So that's why it's so difficult to get that second person in the room. Jane. Thanks.
I'm sorry, I meant to ask this, and I was so entranced in your backstory that I forgot. What I wanted to ask, and I wondered if perhaps when you send something out you could include this, is once all this mediation process has occurred, I do know there are further steps that do need to be taken in some cases in relation to the courts to have things verified and put in place. And it would be for me a completion of this talk to just have some brief document of that when the process is concluded, agreements have been made, what bits need to go where and how does that happen?
Yep. We put a blog on our website a couple of weeks ago, so I'll include a link to that blog which covers what are your options post mediation, because lots of people want to go to court and to get it legalized, but actually a lot of people don't. A very high proportion, they've got an agreement and they happily work with that agreement, because we also find they then come back again a year later, 2 years, 3 years later, when something significant changes in their life or the child's life or the other party's life, they need to review that agreement. So it's quite a dynamic thing. So a lot don't go to court, but there are steps they have to take. So we've got a blog that we will share. I was going to say that'll be another hour if we go into that at this point. So we will share that blog when I send the information around so that you can see future steps. Okay. Anything else before we finish? No. Okay. Well, thank you all. It's been a really good morning, and hopefully you've learned a little bit about how we work as mediators, what we're trying to do and achieve. As you said, there is that link, and that will come around again with you as well. And that just help, if you go to that, it's really simple. The client's details, what they're looking for, your details, so we know where their referrals come from. Takes a minute, but if the client's with you and you can complete that, our team will then pick the phone up usually within a couple of hours of arriving with us, and we will make contact with the client and get them booked in and the case moving forward. Okay. So thank you all, and we'll be in contact shortly with the information, the presentation, the video, and that blog. So we'll see you there. But any other questions in the meantime, please just pick the phone up to us and have a chat. Okay.
Okay.
Thank you very much. Bye-bye.
Bye.
Okay.
Bye.
Thanks very much. Thank you.
Thank you. Bye.